Assalamu alaikum and welcome to the free legal advice show on British Muslim TV. I'm your host Ilyas Bulbulia and I'll be with you for the next hour. As our regular viewers are aware, the free legal advice show provides you, our viewers, the opportunity to call in and ask us any questions that you have on any aspect of English law. On this show, I'm able to cover a vast, diverse range of matters. Matters ranging from immigration law matters, family law matters, criminal law matters. So whatever your legal questions are, please feel free to pick up the phone and to get in touch with me. Two ways to get in touch with me here live in the studio. First of all, you can ring on the landline number which appears at the bottom of the screen. Alternatively, another very popular way of getting in touch is to send us a message on the mobile number which also appears at the bottom of the screen. So to speak to me live, you can ring on the landline number, and to send messages in, you can do so on the mobile number, which is there at the bottom of the screen. Now, on the show, we get numerous calls, numerous messages, which is fantastic. And a lot of these are on immigration law. Now, as I've said, I am able to cover other areas of law as well. So please do feel free to get in touch in relation to other legal matters as well. A couple of minor points before we get going. Obviously, on a live show, it's not possible to take very detailed information from callers who call in. In addition to that, sometimes I need to look at documents before I can advise you further. And it's not always possible to look at documents whilst you're on air. So if it's the case that your matter is complex, I need a lot of information from you, or I need to look at documents before I can advise you properly, then I will ask you to leave your number with the control room, and I'll have that more thorough discussion with you off air once I've seen your documents or I've been able to take more detailed information from you. This is free advice that we provide as part of the free legal advice show. So it's not a problem. If your matter is complex, do still get in touch. If it's the case that I need to speak to you off air, I will speak to you off air as well. We've got a caller who's been waiting. Let's go to our first caller for the day. Hello, assalamu alaikum.
Wa alaikum assalam.
Dear brother, thank you very much for
calling. A couple of questions on immigration.
Yeah, sure, no problem.
If someone getting carer allowance doing 35 hours a week, and the person only getting £270 a month,
Okay.
looking after a person that gets attendance allowance,
Okay.
or carer, whatever it is, can that person invite a spouse to come into England and to get a visa?
Okay.
Or is that income not enough?
Okay, so let's just go through the income for the person in the United Kingdom. You've said that they get carer's allowance. Yep. So that's about £270 a month, carer's allowance. Yep. In addition to that, what else do they get in terms of benefits?
Maybe it is topped up a little bit, making a total of £500 a month.
£500 a month. Okay, right.
Private topping up.
Okay, so £500 a month. Okay. Now, does the person in the UK have to pay any rent for where they live?
No.
That's fine. And do they have to pay any council tax where they live?
No.
Okay. Now, it's roughly just about enough. Approximately, I'm just doing a quick calculation as we speak. 120 times 52 divided by... Now, you need approximately £120 a week, which is the income support rate for a couple. Now, it's just under 120. Let's work with £120 a week. Somebody who's on £120 a week, the monthly figure for that would be around 120 times 52 divided by 12. It's about 520 a month. So more or less, the person's got sufficient income with the figures that you've mentioned.
Right. And the person being invited over as a spouse.
Yep.
If that person doesn't have any money at all and no property or no anything, would that affect the application for the person to come over?
Yeah, it doesn't affect the application at all. So,
Right.
so the
And if,
financial circumstances of the applicant, the person coming over, is irrelevant.
right. And if the person coming over is offered a job for, say, about 15,000 or 16,000 a year,
Okay,
would that help?
they won't take that
Make it
into.
easier.
Yeah, an offer of job will not be taken into account. Now, when you start looking at a job offer for the applicant, which is available, etc., you're looking at exceptional cases where you're saying to the Home Office, look, we don't meet the requirements, but can you consider this as an exceptional case? Those cases generally are refused, end up in an appeal, etc. So my personal view is don't go down that route at all. Look at your
Okay.
own circumstances, and if your own income based on carers allowance, universal credit, which comes up to about 500, if that's enough, rely on that. If that is slightly short, then you can top it up with savings. So maybe the person in the UK, if they manage to have savings of £2,000-3,000, and if they're slightly short on income, the savings of £2,000-3,000 would get them over the threshold. That would be a better way of making the application than relying on potential offer of employment for the applicant who's abroad and coming to the UK.
Right. The last question I want
Sure.
to ask. So to get the person to come over here, you need to get the person, inviting that person to go and to meet the person and take out loads and loads and loads and loads and loads of photographs and just come back here and apply?
Okay.
Or how do you need it?
So certainly the first bit is right. They must physically see each other. So seeing somebody online on a video call, on a Zoom call, that wouldn't be sufficient. So they have to meet each other physically.
And provide evidence with loads of photographs and that.
Yes. I mean, normally you'd need at least around 20 photographs in different settings. So, when they've gone out maybe to a restaurant, to the park, met up with family, different clothes, different circumstances. About 20.
Okay. Following up on that last question, the person might want to go and get married and then come over and take loads and loads of photographs and then come over and apply.
Yeah.
But if the application is then rejected, then that would be end of the line. Would that be a prudent thing to do, or not to get married?
And personally, in my experience, if your application is looked at by an experienced immigration lawyer, they should be able to tell you whether the application will succeed or not. Now, if you go to a lawyer, he looks at the papers and advises you that this application should be successful, financially you're okay, etc., there's no other problems within the application, then I can't see a problem going abroad, getting married, coming back to the UK and making the application. But I would certainly take advice first before taking that step. So I completely understand what you're saying, that you need to be cautious here. But the best way to deal with it is to get the advice first. If you've got the green light from an experienced immigration lawyer that this looks fine, then I think it's okay to go abroad, to get married and to make the application that way. Because
right. I just thought of one last simple question, quick one. If the person getting this is potential, getting personal assistant allowance of about 20,000 or 21,000 a year, that person would be able to bring a spouse over very easily, wouldn't it? A lot better.
So what you've mentioned, you said somebody receiving, you mentioned, is it personal?
No, personal assistant. Contribution to the care, and the council contributing towards the care, and that would amount to about 21,000 a year.
I understand. But the problem with that is that isn't a benefit which is taken into account. that is an income which is taken into account. I think what you're referring to is it's like a care package that the
Yes, that's correct.
I
Yes.
think that's what you're referring to. The council has a care package that they put together. We can't rely on the value of the care package to support the
I
application.
see. Thank you very
I
much.
understand
That
where
was
you're coming from,
important.
but we can't do that.
Thank you very much for talking to me. I'm really very grateful. You clarify it. It's crystal clear now. Thank you.
No problem at all. Thank you.
Assalamu alaikum.
Walaikum salam. Jazakallah. Thank you very much for your call. Thank you very much indeed. Now, I think we have another caller waiting. So let's see. Let's go to our next caller. Hello, assalamu alaikum.
Walaikum assalam, brother. How are you? Okay?
Alhamdulillah, good. How are you? You okay?
I'm good, brother. Thank you very much. I just got one question for you, please, brother.
Yes.
So basically, I had applied for travel documents
I understand. Yeah.
online, but I got to make I didn't make a small mistake
Okay.
with my name on it.
Okay.
I put like I just one word is gone
One letter's gone wrong.
with it.
Yeah, I understand.
Yeah. So what should I do? It's been already done there.
It's okay.
The payment.
Have you done the payment? So are you going to be posting the documents to them now?
Yes, I'm going to.
Okay, all right. So when you post the documents to them, include a letter explaining what the mistake is. It should be fine.
Okay.
To be honest, I mean, we've done that at work as well, where we've got a letter wrong, maybe a number wrong. We include a note or a letter saying, look, sorry, made that mistake.
Very small mistake up with my name.
Don't
don't
worry about it.
I just want to confirm with you guys. Yeah.
Look, you've paid for it already. Don't worry about it. Don't ask for a refund and resubmit it. Simply send a letter with it. Inshallah, should be fine. Jazakallah.
Okay. I'm just worrying. The main thing, I'm just worrying that the process cannot be slow because.
No. Brother, don't worry. Send a letter with it. Inshallah, should be okay.
Okay. Thank you.
Jazakallah. Thank you very much for your call. Jazakallah. Thank you very much for your call. Very common problem at the moment with online applications. A small error, maybe with a letter, with a number. We'll look at that in greater detail after we come back from our break. We're taking a short break. We'll be back in the next couple of minutes. Assalamu alaikum. Assalamu alaikum and welcome back to the free legal advice show on British Muslim TV. I'm your host Ilyas Bulbulia. To speak to me live on air, please ring on the landline number which appears at the bottom of the screen. And as always, if you want to send us a message, text message, you can do so on the mobile number which also appears at the bottom of the screen. Just before the break, we had a couple of callers regarding spouse applications. Fantastic. First caller, brother, called about the minimum income that's required where somebody is in receipt of carer's allowance. And I told the brother that somebody receiving in the region of, on carer's allowance, in total receiving in the region of £500 should be enough. Now, whilst we were on our break, I checked the correct figures. So weekly income where somebody is in receipt of carer's allowance, wanting to sponsor their husband or wife to come to the United Kingdom. They're on carer's allowance. There's no rent to pay. There's no council tax to pay. They would need a weekly income of £117.40. So weekly is £117.40. Now, let's just work it out in terms of what the monthly figure is. The monthly figure for that is £508.73. So there you've got it, the precise amount of money that's required for somebody who is in receipt of carer's allowance, wanting to sponsor their partner to come to the United Kingdom. There's no rent to pay. There's no council tax to pay. It's just literally going to be the person in the United Kingdom, the UK sponsor, and the partner who's coming to the UK. No rent, no council tax, no children, etc. Weekly figure in terms of income is £117.40. Monthly is £508.73. Brilliant. Now, we've got another caller waiting. Let's go to our next call. Hello, assalamu alaikum.
Brother, I just need a couple of some of the advice.
Sure, no problem.
Our son is 33. We were thinking to take him to Pakistan this year,
Okay.
in March, April time, inshallah. He had a little bit hard life, and now he's running a family business.
I understand.
And the business he's a director of the business. He's earning a good money as well, Also, he's got a house on his name, which is freehold property. There's no mortgage or nothing like that. I just like to take some advice from you, whether to apply for his wife from here or apply from Pakistan. What's the best way to go forward?
So in terms of your son's income, is it through his own limited company?
It's through his limited company. Yeah, he's earning a dividend and in his wages as well.
I would definitely advise you to do the application through a UK lawyer.
Sure.
100%. A straightforward application.
He's earning over £20,000.
I understand.
He's earning over £20,000. Would there be any problems to get his spouse over here?
No, absolutely fine. The reason I say use a UK lawyer is limited company income. The way you demonstrate that is slightly complicated, which a foreign lawyer, India, Pakistan, wherever, I don't think they would properly understand the documentation that needs to be submitted. We would understand it. Your accountant would understand it. But a foreign lawyer wouldn't understand it. So if I give you an example, where it's limited company income, we have to submit the CT600. You've got to submit evidence that the company is registered with Companies House. You need a current appointments report. Those kind of documents, I don't think they would understand. The accountant would have to be regulated. They wouldn't be able to check whether the accountant is probably regulated or not. Then there are specific rules about dividend income, the evidence, dividend vouchers. There's then rules about wage slips and P60s, etc. It's slightly complex, which I don't think a foreign lawyer who's not used to dealing with these kind of applications would be able to understand. So definitely, I would advise that you use a UK immigration lawyer for that.
My other question, would he have a problem because he was very involved with the to tell you the truth, he was involved with the law before, and his record is not very good.
It doesn't matter.
But now because he's running his business over here now, and he's got that property now in his name and everything So would he have a difficult to bring a spouse over? Or?
No, none at all. Absolutely nothing to worry about on that front. Not relevant at all. Because if they are going to look at somebody's criminal record, it is the applicant's record that they look at. Okay. If the applicant has committed criminal offences, then that can be an issue when they come to the UK. The sponsor's here anyway. Why should the sponsor be prevented from sponsoring somebody to the UK? So nothing to worry about on that front at all. Is that okay? Does that answer your question?
Yeah, that's brilliant. It was very, very helpful.
Yeah, no problem at all. Jazakallah. Thank you very much for your call. Jazakallah. Thank you very much for your call indeed. Just on that point, for the benefit of our viewers who might be listening, obviously when you make a spouse application, one big issue is how do you demonstrate there is sufficient income to sponsor somebody to come to the UK. Now, see, on that front, you can get a very simple case where the sponsor in the UK is employed. Simple case, employed for a long time in a stable job. And all you're submitting to prove that the financial requirement is met is an employment letter, 6 months wage slip, 6 months bank statements. Very, very simple. But contrast that with the situation that brother called in about, where the income that's been relied upon is limited company income, whether that's dividend income or getting yourself paid as an employee. Complex rules exist over the time period over which income is assessed. There are complex rules dealing with the type of documentary evidence that needs to be submitted. So even in practice, when we get these applications, do these day in, day out, but when you look at spouse applications, the limited income ones are more time consuming, are slightly more complex. You need to be more careful when you deal with those applications. So certainly when we look at getting advice in terms of submitting the application, who should you go to? My view always is go to an experienced UK immigration lawyer who deals with these kind of cases day in, day out. They'll be able to see any problems with the application straight away, which I don't think a foreign lawyer who hasn't dealt with these kind of complex cases, I don't think that person would be able to pick up any gaps in the application, any problems with the application. But Jazakallah, thank you very much for that call. Now, we've had a number of questions coming in, some quite lengthy questions on WhatsApp. So I'm going to start going through that. But by all means, to speak to me live on air, please ring on the landline number, which appears at the bottom of the screen. As always, the mobile number is also there, so you can send messages through on the mobile number as well. Okay, let's look at some of the questions that have been coming through today. Let's turn to our first question, which is again an immigration law question. And the question is as follows. Salams, can I ask you, I made an entry clearance application for my wife to come to the United Kingdom. It's been about 5 months now, but I still haven't heard anything from the Home Office. How long do they usually take to make a decision? Very common question at the moment in relation to processing times, in relation to delays in applications being processed. Now, how long does it take? Well, let's look at the normal processing time. I think that always helps. Currently, I advise clients that spouse applications, majority of in-country applications, take around 3 to 4 months to be decided. However, if we look at this case, it's a spouse application. Normally, it should take 3 to 4 months to be decided, but there are some cases which the Home Office does take longer to decide. They may want to carry out some kind of investigation. For example, they may want to check your records with HMRC, or they might decide that they're going to call you as the sponsor and they're going to call your employer as well and conduct an interview on the telephone. Or they might want to check some other aspect of the application. And that could mean that it takes slightly longer for your application to be decided. So instead of the normal processing time of 3 to 4 months, it could end up taking 5 months, 6 months. That is not unusual. And I know it's difficult where you've done the application, you're waiting for your partner to come over, and time is passing by. 3 months have gone by, 4 months have gone by, you still haven't received anything. You're getting in touch with your lawyer, and your lawyer is saying, be patient, you'll get something. The reality is that the lawyer really can't do anything in that situation either. You are in the hands of the Home Office, and you will have to wait for the Home Office to make a decision. Now, what can be done? The reality is, whatever is done to chase up the application actually never results in a quicker answer. That's my experience. But what are the things that can be done? Firstly, there is an online form that can be completed where you can request an update. So you can submit the online form. I think there's a charge, a small £2-3 charge that you pay for that service. Normally you get an email response back saying the application is still under process. Fine, you can do that. At least you've not missed anything. It's still in the process. That's one thing you can do. Secondly, let's say 5-6 months have passed. You still haven't heard anything. You might want to speak to your local MP and ask them to contact the Home Office and ask them for an update. At least when they come back to your MP, you'll get an idea as to where you are. It might be that all the MP is going to say is that it is still in process, and that's what you've been advised. But apart from those couple of things, there isn't much you can do. Sometimes some lawyers advise some kind of reaction protocol letter being served on the Home Office. I will look at that. We are taking a short break. Let's come back from our short break. Look at this reaction protocol option. We'll be back in the next couple of minutes. See you then. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host Ilyas Bulbulia. To speak to me live on air, please ring on the landline number which appears at the bottom of the screen. And as always, if you want to send us a message with your questions, a very popular way of getting in touch, you can do that by sending your message, text message, WhatsApp message on the mobile number which also appears at the bottom of the screen. Okay. We've had, as always, a number of questions coming in on WhatsApp. Let me go to that next. But as always, if you want to give me a ring, speak to me live in the studio, that is absolutely fine as well. A rather long question that's come in. Let me read the question out first. And then let's look at what the position is. I've tried to look at this over the break, but it does look slightly complex. A brother who's texted in says as follows: I want to request help for my sister Yasmin. Came from Kenya over 2 years ago on a British overseas citizenship passport. Upon landing at Heathrow, the immigration officers allowed her entry but retained her passport. Thereafter, we applied for a right of abode, which was then refused. They suggested she can apply for registration as full British citizen. We applied for that, and after a prolonged period of over a year, they refused her application, claiming that we had not supplied all the required documents. This was an error on their part, because the documents that they had requested evidence that she was not an overseas citizen of India. We had actually already sent it to them twice. We therefore made a request for reconsideration in September last year. So it's about 3-4 months. Please advise as to what we can do to hasten the application, as she desperately needs to clarify her immigration affair and seek employment, as she is at the moment fully dependent on friends and relatives. A slightly complex matter. Any matter which relates to somebody with a British overseas citizen passport is always slightly complex. Nationality law in this area is complex. Now, I would actually need significantly more information in order to advise properly. Now, I grasp what you're saying here, that the person has come over from Kenya with a British overseas citizenship passport. What that would BOC passport, what that would allow is entry into the United Kingdom without having to seek a visa beforehand. It allows you, one of the perks of a BOC passport is that you can come into the UK without having obtained a visa beforehand. But that in itself isn't necessarily the same as being a full British citizen with the normal rights. They call it the right of abode, the right to live here permanently, the right to work, etc. That right doesn't attach to all forms of citizenship. So it may not attach to somebody who has a BOC passport. Now, the issue as I see it then is this. I don't think it's a question of applying for a right of abode sticker in your passport. I think the issue very much is whether this BOC passport that you have, whether your circumstances allow you to have a full British passport, like most people in the United Kingdom will have, or is it that you're only still limited to a BOC passport? Now, that is quite complex. One of the issues that they do raise is whether you've got another citizenship or not. So that's why they're asking about Indian citizenship. Now, if that's the issue, the way you deal with the question of whether the person has acquired Indian citizenship or not is to contact the embassy and obtain a letter from the embassy which confirms that the person is not an Indian citizen. So that's the evidence of not having obtained alternative citizenship. Now, if it's the case that the refusal simply is based on the Home Office saying that they haven't received it, then you've got to obviously wait for the outcome of the reconsideration that's taking place at the moment. The slight problem here is this, that the refusal was in September. So even if you wanted to challenge it by going to court, you would have had 3 months to challenge that. So that deadline has now passed. What you can now do is for them to make a decision on the reconsideration. And if it's refused, you could potentially challenge the reconsideration refusal. So you could say that that's the decision that is being challenged. The Home Office sometimes argue against that, but potentially you could argue that they had new evidence to look at. They've now come up with a new decision after having considered your representations. And let's say that decision comes through in January, February, whatever, and they stick to their decision. They take into account what you say. Potentially, if you're still not happy with that, you could at that stage take advice from a lawyer and serve a PAP letter on them, a pre-action protocol letter on them, basically saying to them that you intend to take this matter to court. You intend to make an application for permission to judicially review the decision. So that's one way of challenging that. The problem is that is still a long-winded way of challenging the decision. There isn't a quick solution to this. But 1 year down the line, we are where we are. You've got a decision already. The time's passed to challenge that. You've applied for reconsideration. Get the decision on the reconsideration, and then take advice on whether you should get a lawyer to serve a pre-action protocol letter on the Home Office. Basically saying to the Home Office that this is the decision I'm not happy with. This is why I'm not happy with the decision. Giving them the opportunity to respond. And assuming you don't get a positive outcome, then within 3 months of the reconsideration decision, going to the High Court with an application for permission to judicially review that decision of the Home Office. Now, these are quite complex matters, and we don't have enough information here to advise on the merits of any appeal, any application for judicial review. So it is complex. I don't know whether you have a lawyer who's engaged, who you've engaged at the moment or not. If you haven't, you should definitely, once you get a decision on the reconsideration, engage another lawyer. I would certainly look at challenging that decision, assuming there are sufficient merits to do so. And at the same time, if you feel that maybe there was something that could have made your application stronger, maybe there was something that you should have submitted which you didn't, you can always then submit another application at the same time as well. So you could have another application running with the other documents that they might have requested, and then at the same time, you know, if you feel that's not going to achieve anything, you want to try and push this forward, you could at the same time pursue a judicial review as well. These matters are quite complex, especially matters relating to somebody who's got a BOC passport and whether they are entitled to a full normal British passport. It's quite complex. You would need advice from a lawyer who's experienced in citizenship. If not, refer the matter to a barrister who advises or has knowledge of citizenship laws in the United Kingdom. So that's basically where we are. it could potentially be challenged. I would take advice, and if it's too complex, get advice from a specialist a lawyer who deals with nationality matters first. But Jazakallah, thank you very much for your call indeed. Now, just before the break, we had a question relating to delay and how can a delay in processing an application be dealt with. And I was saying that in terms of the particular matter we were looking at was a spouse application which had been pending for, from what I understand, for about 5 months, and a decision hadn't come through. And I explained that the way you would challenge that would be, or deal with that, is you may initially want to complete the online form, which is on the government website, inquiring as to the progress of the application. If you don't get any joy there, you could approach your local MP, and the caseworker at the local MP could contact the Home Office to find out the progress of your application. If that doesn't work as well, what else can you do? Our clients say to us, can we go to court? The reality is a delay of 5 months, a delay of 6 months normally isn't sufficient to challenge the delay in court. Though the cases where there has been delay which are successful in court, the failure of a public body to make a decision, that's basically what you would be arguing. Delay cases which are successful are cases where there has been a delay in terms of delay which is calculated in years as opposed to months. You know, as a minimum, there's been a delay of 2, 3, 4, 5 years or something. Not a case where there's been a delay of 4 to 5 months. So it's very difficult to challenge a failure to make a decision, a delay in making a decision in court. So when clients come to lawyers, immigration lawyers, and say, look, what can you do? The reality is there's very little you can do. Raise the inquiry with the Home Office using the online form. Go to the MP's office, ask the caseworker there to get in touch. I don't think it can be challenged by way of judicial review. You could serve a pre-action protocol letter on them. They will respond. So, that's practically you're doing something. Final thing that you can do is maybe raise a complaint about the delay. Again, the problem with a complaint is there is a delay in dealing with the complaint on the part of the Home Office as well. So even the complaint may not necessarily get you anywhere. Now, the good thing is the Home Office does ultimately make decisions on these applications. A spouse application from abroad, okay, 3-4 months is the normal processing time. If that doesn't come through, worst case scenario, 7-8 months, you do normally get a decision. But thank you very much indeed for those calls on delay. That takes us to the next break. Inshallah, we'll be back in the next couple of minutes. Inshallah, see you then. Assalamu alaikum. Assalamu alaikum and welcome back to the free legal advice show on British Muslim TV. I'm your host Ilyas Bulbulia. To speak to me live on air, please ring on the landline number which appears at the bottom of the screen. Alternatively, as always, the mobile number is there for you to send in any messages that you want to send in. A very popular way of getting in touch is to send us a message on that mobile number. So please do keep on sending your messages in. We've had numerous questions that have come in which I haven't had time to deal with. So let me try and go through them now. Okay, let's look at the next question that's come in. Looks like a question on visitor visas. Question is as follows. Hello, my inquiry is regarding my mum's visa refusal to the United Kingdom. A refusal which we've had on 2 occasions. Refusal is based on her being alone in India and her 4 children all living in the United Kingdom. The Home Office has refused the application because they believe she won't return to India. Okay, now we get a lot of questions live on air on visit visas. And even in practice, at the moment, it's the case that we're getting a lot of inquiries relating to visit visas. And it's sort of understandable why there's been a peak in terms of visitor visa queries. Because we've had a couple of years of COVID where there have been restrictions on travel, and it's been difficult for people to travel to the United Kingdom. So there's been literally about 2 years where, in terms of visit visas, there hasn't been many applications being made. A lot of, with the red list countries, a lot of the visit visa applications were actually being put on hold. Now, so that's all sort of clearing now, 2 years down the line. So we're getting more and more visitor applications now. So what are the chances of success where you make a visitor application? Now, it all does depend on not necessarily the sponsor's circumstances in the United Kingdom. It does really largely depend on the applicant, the visitor's circumstances back home. When the immigration officer is looking at a visitor application, what the immigration officer is mainly looking at is whether the applicant, the visitor, has the intention to return to their home country or not after the visit. So that's what the immigration officer has to be satisfied of, that will the visitor return to their home country. Now, obviously, it's not possible for anybody to know, for the immigration officer to know what the visitor's intentions are in terms of what's in their mind. They're not mind readers, so they can't tell what somebody's actually thinking. Are they going to stay? Are they going to go back? So what do? Well, what they do is they look at the visitor's circumstances and they make their assessment based on that. The problem is this, that somebody whose circumstances, and normally it's somebody's financial circumstances that they look at. The financial circumstances may not be very strong. They may not live in comfortable circumstances, but that doesn't necessarily mean that they have no intention to go back. But the problem is that the way the immigration officer assesses the application, they focus too much on those kind of circumstances. And the first thing, in my experience, that they focus on is the visitor's financial circumstances. So where you find that the visitor, and here I think the case is somebody who is potentially elderly, somebody in the late 60s or whatever, they won't necessarily be working. So if you assess their circumstances, it's going to be, generally speaking, unlikely that they will have their own income. They generally won't be employed. They'll be retired. In a lot of countries, they may not be eligible for a pension either. Or even if there is a pension that they are entitled to, it may well be minimal. You know, for some countries, the pension that's been received per month may be in the region of 10, 15 pounds. So a very small amount indeed. So the initial problem is with the assessment of the visitor's financial circumstances. And really boils up, what's their income? So they look at the applicant's bank statements for the last 6 months last year. They look at all the money that's coming in, and they look at, what is it that's coming in? What's the source of that income? If the income isn't very good in their eyes, then that can potentially be a negative in terms of the assessment of the application. If there are deposits coming into the bank account which can't be explained, so somebody's bank statement, let's say, has, in terms of pounds, over the 6 months, for 5 months, the only amount in the bank account is in the region of a couple hundred. And then a month before the application is being made, the balance shoots up to £4,000-5,000. That's a red flag as well. That's unexplained income. That can cause potential problems as well. So it's really a question initially of assessing the visitor or the visitor's partner's income. So you need to do all you can to demonstrate in the best light possible what the visitor's financial circumstances are. It may well be that they own assets, they own their own house, submit evidence of that. It may be that they owned land and other property, submit evidence of that. If they have, they may not be employed anymore, but if they have rental income or income from land which has been leased out, show evidence of that. And what you've got to bear in mind, the second point is, what you have to bear in mind is that the Home Office does want things in black and white. So let me give you an example. If somebody is saying that they have rental income coming in, they want to look at proof that you, the visitor, you own the property. They want to see some kind of lease agreement, tenancy agreement, which demonstrates or which confirms how much rental income has to be paid. They want to see that rental income being transferred from the tenant's bank account into your bank account as well. So they want to see this setup over a period of time before they are likely to be convinced that the source of income being relied on is actually genuine. So you do need to focus on that. Sometimes we get asked that, look, mom and dad abroad, they don't work, they have no income. We send money from the UK to them. Very common scenario. Now, fine, if that's the case, I think you should still demonstrate that. Maybe get the children in the United Kingdom here to confirm that they send money back to the parents, show the money transfer receipts, show the receipt of the money back home as well. So demonstrate that that's the case. That is sometimes a negative as well, because the Home Office sometimes takes the view that, look, you have no independent income of your own. You rely solely on your children who are in the United Kingdom. So it means that you don't have sufficient ties to your own country. But I still think it's worth demonstrating that, look, this is where the money comes from. This is what we live on as visitors in our home country. And get confirmation that these arrangements will continue. Your mom or dad will come here to the United Kingdom. Once the visit has been completed, they will return, and the circumstances which exist at the moment in terms of them receiving monthly money into their bank account or whatever the arrangements are, that will continue after the visit is completed and they're back home as well. So focus really on the financial circumstances of the applicant, the visitor who is coming to the United Kingdom. It isn't sufficient to say that, look, finances shouldn't be an issue because they have a sponsor here. We're prepared to sponsor them. So we're prepared to sponsor them. So why is finances such a big issue? The reason it's a big issue is that these are two completely different things. As a sponsor in the UK, you are showing your finances in order to demonstrate that when, for example, mom comes to the UK, she has a place to live and she will be financially looked after. She will not be a burden on the state. That's why you, as a sponsor, you are showing your financial documents. The reason the visitor, the applicant, your mum, is showing the financial documents is to demonstrate that they live in comfortable circumstances. They have independent income. They are likely to go back. So the purpose behind the financial documents, the purpose is actually different. The sponsor shows the documents for a different reason. The applicant, the visitor, the mum in this case, shows the document for a different reason. And this is not what the rules say, but in reality, what you have is those who live in financially more comfortable circumstances back home are more likely to get a visa if they have their own income. So that I always say, concentrate on finances first. What other things do they look at? if you have family there, children under 18 there, demonstrate that by way of passport copies, other proof that they are living there as well. So family there is quite important as well. But they're the two main things that you need to focus on: finances and close family members who are there abroad. When you're coming to the UK, it might simply be a family visit, or it might be a special occasion, the birth of a grandchild, a wedding that's taking place. Show that as well. That sort of explains to the immigration officer why the visit is being made and why it's being made now. So there are a couple of things that can be done to make the visitor application stronger. What I would say is visitor applications don't have a very high success rate, but you can increase the chances of success by putting more effort into preparing the application properly. It's a lot of hard work, but that is really necessary if you want to increase the chances of the application being granted in your favor. So hope that helps. Thank you very much for all the calls that we've had today and all the questions that you've been sending in. A couple of questions I've not been able to get through. Inshallah, we'll be back next week at the same time. See you then. Assalamu alaikum.